Welcome, everyone. Welcome to the American Museum of Tort Law. My name is Melissa Bird, and I am the Executive Director of the museum. The American Museum of Tort Law is located in Winsted, Connecticut, and dedicated to educating the public about the concept of tort law and its role in American society. The museum aims to shed light on the history and significance of tort law, which deals with civil wrongs and provides a means for individuals to seek compensation for injuries caused by others' negligence or misconduct. The museum features exhibits, artifacts, and interactive displays that explore various landmark tort cases and their impact on safety, justice, and corporate accountability in the United States. It serves as a thought-provoking resource for those interested in the legal system and its influence on consumer protection and public welfare. We are proud to host this national educational event. Tort Law Day 2024 is sponsored by Klein and Spector, Catastrophic Injury Litigators, Bellick and Fox, Asbestos and Personal Injury Litigators, and Laboratories for Democracy, presenting a youth civic challenge, a unique national civics program. We would like to thank them for their generosity and their strong continued support of the American Museum of Tort Law. Today's event will delve into blockbuster torts, including presentations on AI, mass torts, corporate crime, and torts law's role in democracy. We are thrilled to have a dynamic panel of esteemed speakers who will be speaking on these topics. Our speakers today are David Tannenbaum. He is our artificial intelligence expert. Elizabeth Birch, Fuller Calloway Chair of Law at the University of Georgia. Attorney Russell McIver, editor of the Corporate Crime Reporter, and I am also joined by Ralph Nader, who is an activist, author, lecturer, and attorney. He will also be making our closing remarks today. Before I introduce our esteemed guests, I'd like to take this opportunity to encourage all who are watching to visit our website, www.tortmuseum.org. You can take a virtual tour. You can check out our online gift shop, which is stocked full of iconic memorabilia, including stylish apparel, tote bags, and a fascinating library's worth of books, posters, and other literature. Now, let's get underway. I would like to start by introducing David Tannenbaum. David works on artificial intelligence and its effect on consumers. He publishes a newsletter, www.ai newsletterforconsumers.substack.com. That's a mouthful. He worked for Essential Information, a plaintiff side firm, two startups, the Federal Communications Commission, and an NGO he founded that dealt with intellectual property. David graduated from Yale Law School, University of Oxford, and Princeton. Welcome, David, and thank you for joining us.
Thank you. So I should say, if you want to use the newsletter, you just go to AI newsletter for consumers.substack.com, no www. So today I'm going to talk about artificial intelligence and torts and ways that torts can be used to limit AI and protect us from AI's side effects. So I look forward to the questions afterward, and let me begin. So technology has relied on AI for decades. You use it to analyze data, to predict patterns, to automate routine processes, and many other uses. So I'll start with the basics. I know many of you probably know this, but we're just going to start with the basics to get everyone on board. So what is AI? First, AI can do many things. One is natural language processing. Two is inferencing, machine learning, artificial neural networks, and motion manipulation. It can do all those things. But we're really going to focus today on generative AI because generative AI can generate new text, new images, new video, all based on written prompts. For example, if you want to see a little bit of what generative AI can do, you go to ChatGPT's website, and you'll see that you can learn patterns through data. It relies on large language models that use deep learning algorithms. So to make sense of everything that it's downloading and taking into itself, use these large language models, which require a lot of language examples. It can generate new content from all the inferences that it can make from the large language models. And it requires massive amount of data because it's doing everything it seems like a human can do. So it has to have access to all the data that shows sentences, paragraphs, and other things that humans do automatically, but it doesn't know how to do that at first. And getting so much data can be privacy invasive because it collects so much data, and whoever provides the data, and often the data isn't provided by someone who owns a website. It's data that comes from generative AIs looking at all the websites. It doesn't get permission from the websites. Websites can deny the generative AI, but it's rare. So here is how AI describes generative AI. First of all, what is generative AI? I type that into the ChatGPT interface, and it gives me this. Generative AI refers to a category of artificial intelligence algorithms. I won't go all through this, but the key is number 2, content creation. It generates new unseen content that resembles the training data, but it's not a direct copy. So that means that you can ask generative AI a question, any question, and it will use its knowledge of the content that it has taken in and use that to answer your question. And usually you can answer any question that you have. So look, I'll give you a few examples. You can ask it, what is the best food in Washington, D.C.? And it will give you an answer about the best foods, and it'll tell you the best restaurants to go to and what they specialize in to answer the question, what is the best food? You can ask it, how can I find the best lawyers in Washington, D.C.? And it will, instead of giving you the best lawyers, it says, identifying the best lawyers in Washington, D.C. depends on various factors, such as the area of law, your specific legal needs, and personal preferences. But it will give you places where you find the best lawyers, like these various periodicals, Best Lawyers America, Super Lawyers, Martindale Hubbell, and they give you a dozen others. You can find the best lawyers by giving more specific information. And then finally, if you're interested in the World Series, you want to know who will win the current World Series. Now, generative AI can't guess that, but it'll tell you that its knowledge only goes up to October 2023. So it won't give you the answer. It'll say the World Series typically takes place in late October, early November, and it doesn't have the ability to predict the outcome. So it's limited. I mean, this kind of limitation is limitations of humans, and it can't go beyond what humans can predict. So, okay. So AI's benefits in general, they can reduce human error. It can perform repetitive jobs. It can provide digital assistance. It can predict outcomes, and it can make unbiased decisions. And a whole slew of other things, like create new inventions, can analyze and address consumer queries, research and perform data analysis, and analyze large volumes of data. And the benefits are mainly shaped by what it ingests. So if there's a lot of data on how to do something that can figure out, someone says X, you can reduce the human error and say, it's not X, but through my analysis, it's X plus 1. And it'll create the human. So private investment in this generative AI has jumped. You see in all the 2010, 2020, 2021, 2022 are all low. All of a sudden, though, in 2023, it jumps up. And that's because generative AI was more perfected and was made available to the general population. But of course, it has downsides, generative AI, poor predictability, biases, and that's different from the alleged non-biased decisions. Because if it's ingested text that is biased, it's going to be biased with its answers. So this is the whole list, and then there's more. So you can see there's plenty of downsides to AI. So we probably shouldn't rely on AI to give us the right answer, but it goes a long way to getting us the right answer. And by the way, I will make the PowerPoint available to anyone. Just email me. I'll show you my email at the end of this presentation. So are people nervous about AI? Yes. This is 2023 at the top and 2024 at the bottom. And you can see it's increased by 13%. And it's probably going to increase more as artificial intelligence becomes more used. And then it'll probably decrease when artificial intelligence has enough information that it can give helpful answers. But there is a limit on the answers it can give. We don't want it to violate privacy, for example. And that sort of concern contributes to people saying that artificial intelligence makes them nervous. So I'm going to go now into how various entities are examining AI and how they're regulating it. And you might have some questions and you can give them to me after presentation. So the US federal government has taken on artificial intelligence pretty aggressively compared to how it's handled other technological innovations. So Congress, the executive agencies, and the one which I'll focus on today is the judiciary, which will probably act, and it has acted, before all the other branches of government because it doesn't need statute. It doesn't need anything written that users of AI are examining and so on. The US states are doing basically what the US federal government is doing. So you'll hear a lot about California passing legislation that allows it to limit the AIs. And other states are doing that as well. But California is the leader at this point. Internationally, the G7, the European Union, and several countries acting alone are also looking at artificial intelligence and how it can be reined in before it legitimately scares a lot of people. And then privately, the artificial intelligence developers and the executive that are selling the AI engines are also enforcing these things before the federal government. I suspect it's because they're afraid of what the federal government and the US states will impose on them. And the European Union and the European Council are ahead of everyone. And these are making our AI companies very nervous. And finally, academia is looking at AI and figuring out the best way to use AI, the best way to construct AI, and also the best way to restrict AI. So there are key questions when we're looking at it from the court's point of view. So what are the injuries that people are suffering from AI? Who are the victims? Who is suffering from AI? Who is getting the most injured? And what legal resources are available? So these three things are the main questions, but there are others, but these are the three that I will focus on. So there are three different judicial approaches. One, someone can take a statute and say that the defendant violates the statute. It's a little bit too early for anyone to pursue claims in the statutes because the statutes haven't been written or passed, aside from California's, which was passed about three weeks ago. They can rely on contractual liability. The argument there would be that the user expects certain things from the artificial intelligence robot, and they have contract with the provider of the robot. And then the third way is to use tort liability for plaintiffs to assert that the artificial intelligence is causing them harm in some way. And in this presentation, I'm going to focus on tort liability because I think it is the best way to regulate AI. So is AI necessary to involve tort law, or are there mechanisms sufficient? I've gone over them in the previous slide, but I think that tort law is has long been the means by which citizens have regulated new technologies. And in this case, I think that it's the best one to use against AI. So which is best? They can litigate via statutes. This is kind of a recap of the 2 slides ago. Section 230 probably won't work. They can do it through contractual liability and tort liability. And you can see here on the tort liability, there are many harms that tort liability can address. So everything from defamation to negligence to infliction of emotional distress to an invasion of privacy. There are many different areas in which tort law can be helpful. So what are the types of tort liability? One is negligence. It's against someone, well, who is negligent. If a robot is not negligent or the owner is negligent in releasing a flawed artificial intelligence system. There's strict liability. That means even if the owner of the artificial intelligence doesn't know of the problem, it's still going to be liable if it harms consumers. And the third is product liability, which has a bunch of criteria for suing someone about a product that is causing harm, but that's a little bit complicated because of the new nature of the product. And then finally, you can argue that a provider is breaching the warranty of the product safety. That can be used, but again, it's a little bit more complicated than negligence or strict liability. So the benefits of tort law. This first point just makes the point that anyone can use tort law if they are faced with an injury caused by another person. Torts may involve harmful products as they would in a tort claim against the artificial intelligence. And tort law has addressed industries, the whole industry, and large companies in this industry governed by various regulations and laws. So the regulations and laws will be helpful when they're passed, but I'm focusing mainly on now what tort law can give us, not really based on regulations and laws. And what are the limitations of tort law? It lacks degenerative AI, robot lacks personhood and agency. So it's hard to, in theory, you might find it hard to hold AI responsible for its bad actions. But you can get around that, and I'll talk about that a little bit later. There is a lack of reasonable precautions. No one has really set the reasonable precautions that an AI deliverer should follow. And that will come as courts hear the tort cases with regard to AI. AI's behaviors are not easily foreseen or explained. A defendant who is defending against a lawsuit will say, oh, I didn't know that the AI was going to do this, or I can't explain why the AI did this. And some may see that as a limitation of tort law. It's unclear what the requisite standard of care is and whether it has been met. So we don't know how high the standard of care is, if it's strict liability, if it's unreasonableness. This whole range of care is not worked out. But again, it will be worked out in the courts. And then finally, the question of whether we consider AI a liable actor or the manufacturer. If we considered AI as a liable actor, someone wanted to sue AI, it would be difficult to get damages from AI. But the manufacturer, on the other hand, might be more responsible for the damages and can probably pay the damages to anyone who finds that AI is a liable actor. So if we decide to go under torts, there are two major modes that we can follow. First is negligence. So negligence is basically if one person hurts another person, that the court has to assess how much they hurt them and assess what the plaintiff has done to reasonably avoid being hurt. So the pros of that It's been around for a long time. Courts have long found parties negligent, and lawyers know how to sue and defend under negligence because it's an easy standard. And the downside is that the violations of the AI robots are often foreseeable because it's hard to know exactly how the robot will respond to a certain situation because it's just ingested so much information. There's a radio show on AI, and the guy got the robot to say that he should divorce his wife. And he loved his wife. He didn't want to get divorced from his wife, but it was hard for the trainers of the robot to predict that kind of response from the AI robot. Second is, what is the duty of care of the designers, operators, and end users? I mean, it's just not clear exactly what a user has to do and a designer and an operator have to do to avoid negative outcomes. And finally, black box, what is the proof of causation? Basically, this gets back to it's hard to know because the AI collects lots of information. It's hard to penalize the AI for bad information that it acquires because the programmers have just told it to go out in the world and collect everything. So negligence is questionable. So then we would turn to strict liability and maybe apply insurance pool, and I'll get to that in a second. So the benefits of strict liability and free strict liability basically finds that the AI producer, manufacturer, distributor has to just protect the user, no matter what the standard is of what the user is supposed to do. It's just absent those standards, the defendant, the company that makes the AI, for example, has to believe that the AI has done something wrong. And it doesn't matter if the plaintiff doesn't meet clear standards of how it should evaluate. It deals with unwillingness to share data, deters the premature automation of fields where the human experience is still sorely needed. And it can use the doctrine of product liability under the strict liability framework. But the cons are these, I won't go through each one of them, but the economic loss doctrine, the strict liability with AI robots, barriers, entry, and lack of foreseeability. So should we choose negligence or strict liability? The answer, of course, is it to be strict liability. And if you ask an AI what should they use, what should we use, it will give an answer like this. A thoughtful analysis of the facts will be essential. And in practice, many cases involving new technologies, including AI, tend to push for strict liability because it forces companies to internalize risks and protect consumers, even if negligence is not apparent. So there's my name, and you can reach me at that email address, me@davidt.xyz. And if you have any questions or additional points you would want to make around this subject, speak up.
David, thank you for your presentation. Last year, Time Magazine ran an article titled, "Pausing AI Developments Isn't Enough. We Need to Shut It All Down." And it was written by a guy named Eliezer Yudkowsky, who was one of the founders of the field and very well respected within artificial intelligence circles. Yudkowsky sees AI as an existential threat to humanity. And tort law seems to be just an inadequate tool to prevent the potential disasters that he's outlined. What do you make of Yudkowsky's arguments?
That's hard. In this field, it's difficult to iron out which perspective to take. But it's clear that the consumers should be protected. And so if that approach is better at protecting consumers and allows some innovation, I think that's the way to go.
I've been a medical transcriptionist for many years. Lost my job to robotic issues. However, my problem is I'm looking into this as hospitals have hired these services who use these robots who go voice to text, and the text often is wrong and sometimes seriously wrong, giving diagnoses, giving conditions that a patient may not have, and medications that are, as the robot can't pick them all up, it takes time, are given in error. So where does the blame fall on this? Is it because the hospital does not feel that they have to review everything, that what's there seems to be the responsibility of someone else? But yet, if they've hired this transcription service or use AI on their own, are they directly responsible for not taking that middle step?
I'm not an expert in medical law, but I would say that they're both liable. Both of them used something which provided inaccurate results and therefore harmed the patient. So I would say both of them are liable and should be sued.
Camille asks, will the government or the private sector take control of AI?
That's a question nobody knows the answer to. It looks like government is going to pass the regulations and the statutes pretty soon, but the AI industry is knocking on the government and participating with the government in which laws should be passed. So, I would prefer the government would act independently, but given our system of government, the AI manufacturers are probably going to lobby to get their point of view across, and probably their point of view will be enacted, partially at least.
So there is currently a story about a woman whose teenage son was in basically a pseudo-romantic relationship with a generative AI robot on Character AI, which is basically just made to gather information from you and basically make the perfect friend, I guess. So this robot consumed his entire existence and eventually allegedly encouraged him to commit suicide. And his mother has filed a 93-page wrongful death lawsuit, but this was in the U.S. District Court in Orlando. So I was just kind of wondering how she would be able to recover these damages, since California seems to be the only one with statutes regarding this. And then if there's a way to hold the manufacturers liable both civilly and criminally.
Yeah. If there aren't statutes, the court can still act and can still hold the person responsible or the company responsible. And I would hope that they would apply strict liability. But as Congress passes laws and agencies make regulations against this kind of practice, then there will be more that the plaintiff can hang on to. But for now, I think the plaintiff just has to pursue the common law. And I think tort is the common law that they should pursue. But they'll probably, I would love to look at the complaint. I bet there is tort. I bet there's contractual issues as well.
Yeah, hi, David. Somebody just said they lost their job to AI. And I thought, well, there's a perfect question right there. Can they sue about that?
No, they probably can't. I think they probably can sue, but others like on this call may feel differently. So I know that the government is taking steps to retrain people, and they've just started. But I don't think she could. I don't think she has grounds unless she's, unless the employer has promised to keep her on no matter what. But I don't know. I defer to others in this forum for the answer.
Wonderful. You made a wonderful presentation. This is a little bit sideways, but I'm sure AI will be hijacked by the military-industrial complex, to make it easier to commit war crimes, crimes against humanity, genocide. We see it already, in the Middle East now. We don't know because the state secrets how much is already implicated. But is there any chance of amending the Federal Tort Claims Act, which has this automatic exemption from anything in military affairs, because that all sorts of, I don't call them consumers, civilians are being and will be destroyed, in my judgment, by AI unless it's controlled by some kind of international convention. Just like biological warfare, chemical warfare is outlawed. But what's your view of that?
I agree with you that people should be able to sue under the common law, like under torts or under contracts. But I don't know how the law is constructed with regard to the military. If anyone else knows or can speak up, I would appreciate it.
Thank you, David. It was incredibly informative, and I think people probably could continue to ask questions all afternoon. Our next speaker is Elizabeth Birch. Elizabeth Birch joined the University of Georgia School of Law faculty in 2011, and she served as a visiting professor at Harvard Law School. She is the current Fuller E. Callaway Chair of Law and is author of Mass Tort Deals, Backroom Bargaining and Multi-District Litigation. And her teaching and research interests include civil procedure, class actions, and mass torts. She will be speaking today on the pros and cons of mass torts. Welcome, Elizabeth.
Thank you so much for having me. So I want to start. I suspect that even if you think that you don't know what multi-district litigation is, you probably have heard of it in some form or fashion. So if you've heard of the opioid lawsuits or the Roundup cases or the tout cases, multi-district litigation, or short form MDL, is the way that our federal system handles related questions of fact in these types of mass torts. It also applies to things like employment discrimination cases, antitrust, IP. But the majority of the cases that you tend to hear about in MDL tend to be these types of products liability cases. So a couple quick statistics here. If you grabbed a random civil litigant as they filed suit in federal court last year, you'd have a 1 in 4 chance of selecting a plaintiff in a products liability MDL. And if you picked a plaintiff that was actually pending on the open civil docket, then you'd have better than a 50-50 shot of picking a mass tort plaintiff, because those proceedings tend to take a lot longer to resolve. So all this means that a huge number of people who encounter our civil justice system do so through mass torts. And of course, their experiences with the civil justice system shape what they think about our judiciary. So I want to start by telling you about one such person. This was a plaintiff in a procedural justice study that I did. My co-author was Margie Williams. We finished the study in 2022. This is a plaintiff who lives in Alaska. In 2008, she had 2 pelvic mesh implants to deal with incontinence issues. It made it very difficult for her to travel, as you can imagine. And so in 2010, she started looking online to find an attorney to sue the mesh manufacturer, which was C.R. Bard, a New Jersey company. She hired lawyers from Kansas City, Missouri, and they partnered with a Washington, D.C. law firm. So she was hoping to get the mesh safely removed. 3 years later, they filed a complaint in the West Virginia multi-district litigation under what's called a direct filing order. That typically circumvents traditional venue and personal jurisdiction requirements. And the complaint, as a short form complaint, didn't really give her an opportunity to tell her story or share the facts of her particular case. So once that was filed, it joined with over 100,000 others in the West Virginia multi-district litigation. So from there, she says that her lawyer did not keep her informed about the lawsuit, that she wasn't told about hearings that were going on in the case. And when we asked whether plaintiffs would have preferred more opportunities to tell their side of the story, and if so, how much longer, she actually said she would have been willing to wait 100 months, the equivalent of 8 years longer, if she had an opportunity to tell her story. But instead, her attorney wanted her to settle. And the terms of that deal were private. But some of the past research that we've done reveals that aggregate settlements often can contain provisions that try to encourage plaintiffs to go into the settlement. So for example, they can include requirements that participating attorneys have to recommend that 100% of their clients take the settlement. Others include walkaway provisions that allow the defendants to exit the deal if they get too few plaintiffs who sign up to settle. And others even require attorneys to withdraw from representing clients who refuse to settle, which, of course, if you take ethics, this is sort of known as the hot potato rule, that you're not supposed to drop your client like a hot potato just because they don't want to settle when it is that you want them to. Her case finally settled 6 years later, and she says that she's still unable to have the mesh removed in a safe way and that she feels like she doesn't matter. So what I thought I would do is just give you a sense as to the data that we collected. And this is based on a study that was conducted way back in 1989 through the nonpartisan group RAND called Perceptions of Justice. We used a lot of the similar types of questions, but made it specific to multi-district litigation. And over the course of 2 years, we aimed to reach a random sample of plaintiffs through a whole variety of means. So we circulated the link to the study through the press. It was in the New York Times. It was in public and private Facebook groups that were dedicated to these underlying harms like pelvic mesh and breast implants. We also contacted 42 lawyers who were involved in these multi-district proceedings, either as lead plaintiffs' attorneys or as individual plaintiffs' attorneys. But we got the distinct idea that they didn't particularly want us asking questions like this. So of the 293 responses that we received, we were able to verify that 217 were actually in multi-district litigation and that they were plaintiffs in our data set. So they came from 42 different states, diverse education levels, diverse backgrounds. They were represented by 295 different attorneys from 145 different law firms, and their cases originated in 32 different state and federal courts. So in addition to some of the sort of more typical demographic and geographic diversity, their responses also varied substantially, which suggests that it's a representative sample, but we don't know. This study is the very first of its kind. And there is no underlying database of multi-district litigation plaintiffs that exists for comparison purposes. So it's really impossible to say whether this is representative or not. We'd love to replicate the study on a much broader group of plaintiffs in several different multi-district proceedings. So let me just give you a quick overview of some of our basic findings. They were somewhat surprising. So first of all, we found that plaintiffs were uninformed about the lawsuit, but it wasn't for their lack of interest. In fact, most of the plaintiffs indicated that they hired counsel, but a number of them couldn't remember what their attorney's name was. Slightly more than that could recall the name of their law firm, and a small minority was able to identify whether their lawyer actually served in a leadership position. So for clients who want to actually be in control of their lawsuit, as multi-district litigation assumes that they are, they have to know who the judge is and they have to know where their case is proceeding. But as you can see from our statistics up here, 50.6% couldn't identify where their lawsuit was pending. And when we asked, what's the name of the judge assigned to your case? 69% had no idea. So we asked the participants, why are you suing? What is it that you're hoping to accomplish out of this lawsuit? And most of them actually wanted to prevent the same harm from happening to other people. Compensation was, of course, important as well. They either wanted medical expenses or expenses more broadly. It was also important for them to try to hold the companies accountable. So 77% of the respondents hired counsel, but more than half, unfortunately, were somewhat or extremely dissatisfied with their lawyer. So we tried to figure out why that is. Why are they so upset with their attorneys? And what we found is that although 54% of respondents felt like they had a chance to explain their situation to their lawyers, and 45% felt like their lawyer explained things like fees and costs to them, it turned out that 60% disagreed that their lawyer kept them informed. More than 2/3 felt like they didn't really understand what was happening with their case. 49% didn't feel like they understood what the risks and benefits were of, say, settling a case or proceeding on towards trial. and 51% didn't trust their lawyers to act in their best interest. Delay was also a pretty big factor in plaintiff satisfaction. So most respondents' lawsuits lasted 5 to 6 years, but some of the cases lasted up to 11 years longer, which, as you can imagine, is an extraordinarily long time to have to wait for any sort of justice through the system. So about 3/4 said that the delay was unreasonable. We heard comments like, my suit has been filed for 7 years, I'm 15 years injured. Another said, and over the 5 years that have transpired since we filed this lawsuit, we have not received a trial date. This litigation process is simply broken. The pain and suffering of many lives trapped in this mall deserve justice, and yet we wait. Justice delayed, justice denied. And yet, maybe this is surprising given that they're already frustrated with the delay, but 60% said they would wait even longer if it actually gave them an opportunity to tell their story in court. This could have been through trial, it could have been perhaps through something different. So when we looked at opportunities for participation, this wasn't particularly surprising. So only 3 of our respondents reported attending a hearing, and most didn't go to hearings because they weren't aware that they could go. As you can imagine, distant forums and the cost of travel made it very difficult for participants to attend. A number of them felt like they hadn't been told about where the proceedings were. And so these findings, to me, are particularly troubling given that efficiency often justifies this multi-district litigation system. It seems like the efficiency is only happening on the defendant's side and not on the plaintiff's sides. So moving cases to distant forums, particularly for injured plaintiffs, puts real burdens on them, particularly on their ability to participate in the proceedings. So we also asked about judges and claims administrators. They didn't fare a whole lot better. More of the respondents were neutral about how the judge treated them, which was good. But more than half didn't think that judges had the necessary information to make informed decisions about their case, or relied on accurate information, or really took the time to explain rulings to them. And then when it came to settlement information, over 3/4 were extremely dissatisfied with the settlement process. So the Model Rules of Ethics, Rule 1.8G, requires that lawyers tell their clients what the entire amount of the settlement is, sort of what the whole pie looks like, and then what their individual portion of the pie is, as well as what everybody else is getting, and then explain how costs and fees are being apportioned among the clients. So it was really surprising to learn that less than half knew anything about whether their claim even qualified for settlement before entering a settlement program and being dismissed from the litigation process. And I think maybe our most dispiriting statistic out of all of this is that overall, only 1.8% of our participants felt like their lawsuit accomplished what they hoped that it would. So when we asked them about why that was, their answers really focused on their poor quality of life, the low compensation that they received, and the fact that the product was still on the market. So when we correlated their litigation goals, in other words, what did you want the litigation to do, with their dissatisfaction, it's maybe not surprising to learn that the strongest correlation was between those who sued trying to protect others, and then those who were unhappy that the product was still available on the market. So we didn't ask about specific settlement amounts, but we did ask whether the settlement met with their expectations. And among those who settled, about 75% were dissatisfied with the outcome, and 79% reported that their recovery was less than they expected. So I'm close to ending here, but I just wanted to talk a little bit about why plaintiffs know so little. In other words, what's the source of information loss? First of all, multi-district litigation moves plaintiffs to courts across the country. So it means that instead of walking down to your local courthouse and attending a trial that's relatively close by, that the plaintiff's cases are much further away. If you look at this particular slide, I know it's hard to see what's going on here, But all of the things on the left-hand side, all of the different states, are the states of origin where the case was originally filed. And then the filings on the right side are the districts in which the cases were sort of sucked. And you can see this big Southern District of West Virginia where all the pelvic mesh cases ended up. But if you're a plaintiff in Alaska or Alabama and your mesh cases in the the Southern District of West Virginia, then it can be really hard to keep up with what's happening to your case. The second reason that I think we have information loss is sort of a breakdown of the traditional attorney-client relationship. In multi-district litigation, you have layers of lawyers. You have a lead attorney that's selected by the judge, and that lead attorney's information is supposed to trickle down to the individual lawyers, and that may or may not happen. I think that that's due in part to what we think of as like the rise of volume lawyering. So it's no secret that tort reform has changed lawyers' economic calculus, and that's led to the proliferation of bulk representation. So on the one hand, we could say that that's a good thing. You know, it used to be that elite tort lawyers rejected 9 out of the 10 clients who walked through their door and said that we can't represent you. Now we have more cases entering into the system, but many of our participants felt like they were treated like just another number. Being one of many meant that participants knew little about what was happening in their case. And we saw that cases are sometimes bought and sold between attorneys, almost like baseball cards would be. So prompted with my lawyer kept me informed about the status of my case, 59% of the respondents strongly or somewhat disagreed. So it turns out that only 16.6% had actually talked with their attorneys, that the attorneys weren't really sending a lot of client updates, but our initial assumption that the lawyers were the ones reaching out tended to be wrong. So when participants were specifying other in our survey, they volunteered that they were actually the ones who were tracking down their lawyers, trying to get information about their case and what was happening with their lawsuit. So when the lawyers did contact them, many of them felt like it was to pressure them into settling. Without knowledge, a number of the clients were frustrated that they weren't able to effectively monitor what their lawyers were doing or to understand the decisions that were being made on their behalf. And so overall, it just felt like the participants felt like justice was not being done. So I'll end the slide share here, and I'll just mention a couple of things that we would hope to see change perhaps in the future. The first one is we'd really love for MDL judges to consider conflicts of interest when they're appointing lead attorneys. As you can imagine, there are adequate representation issues. Not all plaintiffs have the same sort of claims, and not all plaintiffs are alike. The second thing is that we'd really love to see judges making hearings available through technology. We've all lived through the pandemic. My elementary school child at the time attended class on Zoom. We're all here via Zoom. If we can do it, then it seems like courts would have the opportunity to make the hearings that were available to plaintiffs in distant forum available to them. And then finally, I would just say that after any sort of a global settlement has been reached, that the judges should offer to remand cases who don't want to settle. That gives plaintiffs the freedom to return to their court of origin for a trial if that's what they really want. And it also provides non-settling plaintiffs with some bargaining leverage within the MDL and even with the defendant itself. So they can say, I'll see you in court if I don't want your settlement offer. So I'm happy to take questions.
What is your view on the multi-district opioid litigation?
It's a complicated MDL. You know, it's been going on for a number of years now, and there were questions really early on about some of the things that I've mentioned in this presentation, like adequate representation. The tribes and the NAS babies in particular were trying to get out of the MDL because they didn't feel like their views were being heard. And of course, now we're hearing sort of less and less about it as the election is ramping up. But there have been a number of settlements. You have several of the defendants that have wound up in bankruptcy, like Purdue Pharma. And we had the Supreme Court just last year decide that the Sacklers couldn't sort of free ride underneath the bankruptcy umbrella on the back of Purdue. So it's still very much an evolving situation, I would say.
Thank you.
My question is about a wildfire situation I was involved in, a lawsuit, and I waited 7 years, and the attorneys never gave me, like you've been talking about, the attorneys never gave anybody any indication of anything, and they had law clerks, emailing and texting us once every 6 months, 7 months. Anyways, in the end, it was a $28 million lawsuit with the Southern California Edison here in California. And they basically won't disclose any information about how the judge made their decisions. And I feel like they unfairly compensated myself and other people I know. And the lawyers seem to be taking all the money.
Well, I'm so sorry to hear that. I am not familiar with the ins and outs of California's ethics rule in particular, but if they follow the model ethics rule under 1.8G, you're supposed to have the opportunity to review all of the information. You're supposed to know what everybody else is getting and then what your settlement itself is before you agree to go into the settlement. That information is just part of the fabric of what lawyers are supposed to give you. And I would think that at the very least, you would have the option to see the settlement agreement itself. So I would keep asking. And if you don't get the answers that you want, then maybe talk to the California State Bar and see if they might be able to step in.
What, if anything, did you discover about challenges that injured parties experienced finding a law firm to take their case versus providing excuses by the attorneys who say to themselves, it's not worth it. The perceived compensation would be less than their time is worth. Or too many factors.
So I think it really depends on the type of injury that we're talking about. This brings to mind the GM ignition switch litigation. And, a lot of it broke open here in the state of Georgia through a case that was brought on behalf of Brooke Melton's family. But that was not the first case. So there were a number of people who died in Wisconsin. And when they went to try to find a lawyer to represent them, they were told, we can't take on General Motors because there's a cap on damages. And they didn't have a lawyer who was willing to take their case, and so more people ended up dying because we had these sorts of caps on damages. Finally, it was filed here in Georgia. Of course, we're dealing with tort reform ourselves, but Lance Cooper was the one who broke that case. The Meltons decided that they didn't want to settle on confidential terms and that they wanted to make sure that everybody else was protected from this, and so they ended up filing a number of claims with the government, which broke open the whole recall. And turns out that even the initial recall didn't recall all the vehicles that had been affected. So I would say it is a problem, and it really varies depending on the type of tort that's at issue.
Elizabeth, wonderful presentation, and I'd like you to address, if you can, something that's a little bit at the margins of what you have discussed, and that is the influence of the presiding judge in the multi-district litigation, in particular with regard to Boeing and the 737 MAX, especially when you have issues of law that are very discretionary. Choice of law is a characteristic example. It's all the circumstances, and the judge doesn't want to have all these cases go to trial. So he has the authority to defer discovery, depositions, and a whole host of things that indirectly coerce plaintiffs. And it seems like it's, other than mandamus, which is like a Hail Mary pass, the judges, and maybe the multi-district litigation rules have to change on that score. They seem to have the ability to basically batter and coerce the plaintiffs into accepting a settlement because he has basically all the cards in his own hands that can't be reviewed.
Yeah, I agree with you 100%. I have proposed that you have something called episodic remands. So, the whole point of multi-district litigation is to have common discovery. Well, it turns out that a number of the plaintiffs might have injuries that really fall outside of what common discovery might be useful for. So at that point, it seems like they should have an opportunity to go back to their regular court and pursue their claim in their court of origin. even if there's been a proposed settlement or a major ruling on summary judgment or on a choice of law issue, then there seem like the number of plaintiffs who would not be well served by the lead lawyers in that respect. And so, I mean, there has to be some sort of an exit mechanism or an appellate mechanism. Otherwise, you wait until the very end of the case, and you're oftentimes kind of strong-armed into a settlement that you might necessarily not want to take. And if you settle, of course, you've consented, so you can't appeal any of the issues that have troubled you thus far. And if you don't settle, then oftentimes you're subject to something called a lone pine order, which requires that you produce specific evidence, expert evidence, oftentimes of causation, and shortcuts the summary judgment process. So it's a real problem. It's a problem that I've written about in the Mass Tort Deals book, and it's something that I hope will change.
You mentioned that many clients felt that they hadn't been heard, and many would have waited longer if it meant they could be satisfactorily heard. Are non-disclosure agreements a big part of these settlements? What is preventing people from being heard?
So I think that the front end process is that you have so many plaintiffs who are in a multi-district litigation, and you may have a single lawyer who is representing 1,000 people in an MDL. And so instead of having a regular complaint where you would include all the specifics that tell your story, even in the complaint, you have one of these short form, well, let me just, check the box. Here's my manufacturer. Here's the cause of action that I'm including. And you really don't have, even in the complaint, those traditional storytelling opportunities. I don't think everyone wants to go to trial, but there are a number of people who enter into the system with the idea in mind that they're going to, sort of take the witness stand and be able to speak truth to a powerful defendant. And so there are different opportunities for storytelling at different stages of the litigation. Most plaintiffs aren't deposed, for example. Not that deposition is sort of a fun thing to go through, but it does give them an opportunity to say, here's what I experienced, here's the harm that I feel, and I want some sort of redress for these injuries.
I wondered if the removal of a dangerous product, Elizabeth, from the marketplace is a standard part of MDL litigation, or is this something that's always separate? I mean, it seems very essential and basic if a product is harming people. Thank you.
Yeah, I absolutely agree with you. It doesn't always happen. I think oftentimes lawyers assume that the primary goal is compensation for the plaintiff and not the removal of the product from the market. But at least in the pelvic mesh arena, so many of those plaintiffs really wanted the mesh taken off the market. It has been taken off the market, as I understand it, for pelvic organ prolapse, but it's still being used in SUI, which is for more minor incontinence issues. So, a number of the plaintiffs are very concerned that you're still using mesh at all. And it's frustrating, and it really varies by proceeding.
Do you find that in the MDL cases, a greater percentage of them are brought because of recalls that consumers are advised of and sometimes don't even get to find them? The second question part of this is when a judge leaves a case and another judge takes over in the middle of this process, how harmful or how beneficial can that be to these cases?
So in terms of recalls, I think recalls certainly do trigger tort cases to come into the system, which is what we would hope to be the usual course of events, that the government would get involved. They would determine that there's a faulty product on the market and that they would take steps to take that product off the market. In other cases, the product doesn't get removed from the market until there are lawsuits. So you really have lawsuits that are putting pressure on the manufacturer and sometimes on the FDA to remove the product from the market. As for the judge, when you change judges midstream, it's always a little bit of a gamble, and it depends so much on who that judge is. And if you have some agency in front of that judge, the ability to talk to that judge. It can also vary depending on whether your lawyer is a lead lawyer in front of that judge. So if your judge doesn't choose your attorney to speak on your behalf, then it can be really difficult to feel like you have been heard at all. So, unfortunately, I don't have a uniform answer for you, but it's very judge dependent on who your new judge might ultimately be.
What are the major abuses of MDL by corporate defendants?
Ooh. I mean, I think multi-district litigation has really worked in favor of corporate defendants. When I teach mass torts and I teach complex litigation, one of the things that I explain to my students is that if you are general counsel for a big company like Merck or Pfizer or General Motors, and you're facing this onslaught of lawsuits, the thing that you want most is to be able to have closure and reassure your stockholders and not have that kind of litigation hanging over your head. And multi-district litigation, more so than anything else, does that because it brings all of the plaintiffs together. It gives them a center of gravity. Now, of course, there are often state court plaintiffs as well, but based on changes to personal jurisdiction doctrine with the Bristol-Myers Squibb opinion, more and more those state court cases tend to be filed in the defendant's home forum, either where they're incorporated or where they have their principal place of business. And so the defendants are really getting the advantage of centrality. They have coordinated discovery. They're not being subject to depositions more than once, sometimes a few times, but certainly not the tens of thousands of times that the number of cases would suggest. So, I do think that the corporations are the ones who tend to benefit primarily from this sort of coordinated effort. We would hope that that efficiency would also redound to the plaintiffs, but these cases tend to take so long just because there are so many of them in the proceeding.
How do you avoid the arbitration clauses and many of the agreements we have to sign in fine print contracts?
If only you could avoid them, right? That it is almost impossible, but one of the things that I have seen some lawyers doing is actually taking corporations up on the filing of individual lawsuits. So, for example, some of the Uber cases, there was a law firm that filed thousands of requests to arbitrate in these Uber cases. And at one point, Uber went to the judge and tried to get out of the arbitration, saying, there are just these too many arbitrations, it's getting too expensive. And the judge in California said, essentially, you made your bed, go lie in it. So you can imagine that maybe the corporations are starting to rethink some of these arbitration clauses. That's the hope, at least.
Excellent. Thanks so much, Elizabeth. It was excellent and
thanks so much for
revealing.
having me. I appreciate it.
Great. Next up is attorney Russell McIver, who is editor of the Washington, D.C. based weekly newsletter, Corporate Crime Reporter. He is also author of Corporate Crime and Violence, Big Business Power, and the Abuse of the Public Trust. Welcome, Russell.
Thank you, Melissa. And thank you, Ralph, Hannah, Melissa, and John, and all those others who helped organize this event. As Melissa said, I'm the editor of Corporate Crime Reporter, which is a legal print newsletter now in our 38th year. We run every week a question-answer format interview. So over the course of the publication, we've interviewed over 1,800 prosecutors, defense attorneys, activists, journalists, anybody who our readers would like to hear about who have an interest in corporate crime. And you can see a list of all of those on our website, corporatecrimereporter.com, including highlights of articles from the print edition. The first person we ever interviewed was in April 1987. It was a gentleman named Rudolph Giuliani. Giuliani was at the time the United States Attorney for New York, and he was being propelled to be mayor of New York by his active prosecution of corporations in corporate crime cases. Back then, Giuliani and other federal prosecutors would investigate a corporation and, if the facts warranted, bring a criminal case. Most of those criminal corporate crime cases ended up in guilty pleas. That's much different from today, where we've morphed into a situation where the vast majority of settlements are with these deferred and non-prosecution agreements. When the Tort Museum invited me a couple of months ago to speak on the subject of crimes as torts or torts as crimes, I Googled it And the first article that came up was an article by Professor Richard Epstein. It was called The Tort Crime Distinction, and it was published in University of Chicago Law School in 1996. Epstein is one of the most prolific legal scholars in America on topics of torts and corporations. And he's like a corporate weather vane. So if Epstein's concerned about a legal trend, then most likely major corporations and their lobbyists are concerned about it also. And the reason Epstein and major corporations are interested in the tort crime distinction is because when it comes to corporate crime enforcement, corporations and their allies are all for what they call limited government. And translated, limited government means handcuffing the corporate crime police. So while corporations do not like at all the reach of tort law and tort lawyers, what they fear more is when tort cases seep into the criminal courts and morph into criminal cases where the states and the federal government bring the power of the state to bear with criminal sanctions. Now, many trial lawyers are also not happy when their tort cases get tangled up with criminal courts, but for a different reason. Tort lawyers fear that the parallel criminal action will mess up their settlements. 20 years ago, law professors from the other side, Thomas Koenig and Michael Rustad, coined the term crim torts, CRIMTORTS, to describe civil actions that concurrently fulfill the private function of compensating injured claimants while serving the broader public purpose of controlling socially harmful behavior. They say, Koenig and Rustad say, that a crim tort is a hybrid that blends the principles of criminal law and tort law. And in legal journals throughout the years, they've explored the difference between the manifest and the latent functions of crim torts as civil punishment. They say the manifest functions of crim torts are punishment and deterrence, but crim tort remedies also arm ordinary citizens with the power to return society to equilibrium through deterrent power of punitive damages embedded in tort law. The latent function of crim torts, they say, are the remedy's expansive societal functions, such as enabling private enforcement of the public law, educating the larger community about the limits of appropriate conduct, allowing public stigmatization of the wrongdoer, and producing a sense of fairness within the larger society. Koenig and Rustad say that crim torts, or their functional equivalent, are urgently needed in this century because the criminal law, by its very nature, lags behind other social institutions. Now, my view is that the criminal law obviously shouldn't be lagging behind other societal institutions, that the reason it's lagging is because of corporate power. And criminal law still has an important role to play in controlling illegal individual behavior, and it should play a similar role in controlling wrongful corporate behavior. So let's start with the hypothetical case of a driver driving down a two-lane highway. The driver is texting while driving and not paying attention to the road. If distracted while texting, the driver crosses the center line, smashes into an ongoing vehicle, and kills someone in the other vehicle, there undoubtedly will be tort lawsuits against the reckless driver, but there'll also be criminal charges by the state charging the driver with reckless or negligent homicide. And if you look up these cases, the driver most likely goes to jail. But what if the reckless party is a corporation? Egregious cases of corporate recklessness are often investigated or prosecuted as crime, but the outcomes are generally poor, not because the cases are not ripe for criminal prosecution, but usually because of lack of prosecutorial resources, a conflicted criminal justice system, or just lack of political and prosecutorial will. In short, corporate power tilts the legal playing field in the favor of the corporate criminal. To get a sense of how this works, let's take a look at a handful of clear cases of tortious corporate conduct that were prosecuted as crimes. Almost 40 years ago now, more than 40 years ago now, I drove to Elkhart, Indiana to cover a criminal case. It was the state of Indiana versus Ford Motor Company. The state had prosecuted Ford Motor Company for reckless homicide in connection with the deaths of 3 teenage girls who were killed when their Ford Pinto was rear-ended at a slow speed. One of the girls realized she had not put her gas cap back on when she went to the gas station and pulled over to get out to get it, and a pickup truck rear-ended her. Now, they weren't killed by the impact of the truck on their Ford Pinto. They were instead burned to death when the gas tank broke open and the Pinto caught fire. In these Pinto cars, the gas tank was placed in front of the rear differential. And when rear-ended, differential would slam into the gas tank, and the bolts from the differential would act like a can opener on the gas tank. The gas would leak out, a spark would catch fire to the car, and the driver and passengers would be incinerated. Now, at the time that this criminal case was brought, there had already been hundreds of tort lawsuits against Ford. And one of those tort cases, right there, I've been to the Tort Museum in Winstead, and it's right at the center of the Tort Museum. I think it was Grimshaw versus Ford. Through discovery in that and other cases, the tort lawyers dug up a memo from Ford showing that they were doing a cost-benefit analysis. And in the memo, Ford asked, okay, we've got a problem here. If we fix the gas tank, how much is that going to cost? $11 a car. And if we pay out the tort damages, how much is that going to cost us? And they made the calculation that it was cheaper to pay out the tort damages. Now, the memo was reported by Mark Dow. He was a reporter at Mother Jones. And Mark and Ralph went to a press conference at the press club, and it got a lot of publicity. Michael Constantino read about that press conference. Michael Constantino was a conservative Republican district attorney in northern Indiana and a part-time prosecutor there where the 3 teenage girls were killed. He was outraged when he read about the Pinto memo and learned about the deaths of the girls very close to him. On September 13th, 1978, an Elkhart County grand jury, at the urging of Constantino, indicted Ford on 3 counts of reckless homicide for marketing an unsafe automobile. It was the first time in American history that a corporation was charged with murder in connection with a defective product. Also, I believe the last time. To defend against these charges, Ford hired a hotshot, probably then the premier corporate criminal defense attorney in the country, James Neal from Nashville, Tennessee. And he had all the resources of a multinational corporation to get Ford off the hook. Constantino, the prosecutor, on the other hand, he had very few funds, and he relied on volunteer law students from nearby Notre Dame Law School. Ford's lawyer, Neal's first move was to get the trial removed from Elkhart, the city, to a small rural town 80 miles to the south. And I report on this incident in my book, Corporate Crime and Violence. In this small town, the premier legal firm, these 2 guys, one was the judge, and the other was the judge's best friend and co-counsel. Neal hired the co-counsel as Ford's local counsel in Winnemucca. And as a result, the judge, for whatever reason, the judge refused to admit key evidence against Ford. And those evidentiary rulings played a role in the jury finding Ford not guilty of murder. So there's one case where, yes, a criminal charge was brought by a conscientious prosecutor, but because of a lack of resources and overwhelming legal power on the other side, there wasn't a fair outcome in my view. Another case is a case that was mentioned earlier in the discussion with Professor Birch, and that's Purdue Pharma and the opioid OxyContin. In 2020, the Justice Department forced a guilty plea out of Purdue, and the company admitted it marketed and sold its dangerous opioid products to healthcare providers, even though it had reason to believe those providers were diverting them to abusers. The company lied to the Drug Enforcement Administration about steps it had taken to prevent such diversion, fraudulently increasing the amount of its product it was permitted to sell. Purdue also paid kickbacks to providers to encourage them to prescribe even more of its products. Now, that guilty plea was in 2020, but the reality is the Justice Department could have brought similar criminal charges against Purdue executives 14 years earlier. Now, we're talking about 70, 80, 100,000 people dying a year from opioid overdoses in this country. That's like mass killing. And here were a group of lawyers in the Western District of Virginia, prosecutors, federal prosecutors, who wanted to move up the chain, right up to the top of the corporation, to the owners, and bring criminal charges. They felt they could move up the chain by the way they usually do these prosecutions. And they were stymied by corporate political pressure at Main Justice. Now, if you want to spend a few minutes to learn about this, probably this is the most insightful thing on the web to learn about corporate power when it comes to criminal prosecution of corporations. It's a New York Times mini documentary, and it's called A Secret Memo That Could Have Slowed an Epidemic. So you can type that into Google, secret memo that could have slowed an epidemic. And what it portrays is this, that these federal prosecutors in Virginia wanted to bring criminal charges against Purdue as far back as 2006. And had they been allowed to bring those prosecutions, tens of thousands, maybe hundreds of thousands of deaths could have been prevented. And why weren't they allowed to bring those charges? Because the corporate powers that be went straight to the Justice Department, above the heads of those line prosecutors. Now, remember our first interview ever in Corporate Crime Reporter from April 1987. The corporate crime buster, Rudolph Giuliani. Well, catch this headline from a Barry Myers story in the New York Times, December 2007. Under attack, drug maker turned to Giuliani for help. And this is the reporting. In Western Virginia, far from the limelight, United States Attorney John Brownlee found himself on a telephone call last year with a political and legal superstar, Rudolph Giuliani. For years, Mr. Brownlee and his small team had been building a case that the maker of the painkiller, OxyContin, had misled the public when it claimed the drug was less prone to abuse than competing narcotics. The drug was believed to be a factor in hundreds of deaths involving its abuse. Mr. Giuliani, celebrated for his stewardship of New York after 9/11, soon told the prosecutors they were wrong. In 2002, the drug maker, Purdue Pharma of Stamford, Connecticut, hired Mr. Giuliani and his consulting firm, Giuliani Partners, to help them stem the controversy about OxyContin. Among Mr. Giuliani's mission was the job of convincing public officials that they could trust Purdue because they could trust him, unquote. And what we learned from later reporting from Barry Meyer at the Times is that Purdue Pharma put its thumb on the scale at the Department of Justice and thwarted a criminal prosecution. The Times got a hold of this 100-page prosecution memo written by federal prosecutors in 2006. And had the prosecutors been allowed to move on their memo and bring felony charges against key Purdue Pharma executives and proceed in a full-out prosecution of the company and its high-ranking executives and owners, the epidemic could have been limited. But these corporate criminal defense attorneys representing Purdue went over the heads of line prosecutors and limited the range and scope of the prosecution. That documentary that I mentioned, that I'm encouraging everyone to watch, very short and very revealing, opens with a man who was at the corner of the power play, Paul Pelletier, who was at the time at the fraud section at Main Justice. And we interviewed him in 2021, and this is what he said. Those prosecutors wanted to prosecute the three principal executives that they had evidence against for a conspiracy that lasted quite a long time to off-label market to foist this drug they knew was addictive. Instead, the corporate lawyers went to Main Justice to nix the prosecution from above. Now, prosecutors cited evidence in their memo that Sackler family members who owned Purdue were sent reports about problems with the company's drugs. But that evidence never came to light because the recommended felony charges against the Purdue executives never went forward. Instead, 3 executives under a deal with the government pled guilty to a misdemeanor. They had insisted they did nothing wrong, and the company denied there was a cover. And there are other similar cases where the corporation exerts its influence at Main Justice. And we asked Pelletier about this, and he told us this. Main Justice has an important role in reviewing corporate and executive prosecutions. there should be a public reckoning about the decisions and how they are made, Pelletier said. Not having a public reckoning and not being accountable to the public about those decisions creates the potential for well-heeled lawyers and companies to influence the process in an inappropriate way. So there you have a federal prosecutor, Giuliani, becoming a corporate criminal defense attorney and doing that kind of work. We reported on a more recent case in Boeing where you had the U.S. attorney who cut the dirty deal with Boeing, the deferred prosecution, going to work for Kirkland and Ellis, the defense firm with whom she negotiated the deferred prosecution agreement. The families were outraged by the U.S. attorney going to the defense firm within a year of the agreement. They were outraged by that and by the lack of transparency and lack of any consultation with the victims. And Pelletier told us that this revolving door is a huge problem of perception, if nothing else. The perceptions created by the revolving door and the realities underpinning some of the revolving door hirings create a huge problem for the Department of Justice. And he wrote an article in Atlantic Magazine, How to Actually Prosecute the Financial Crimes of the Very Rich. And he says it's about the failure of the Department of Justice to prosecute high-end financial crimes. He focused on the deterioration nationally of the Department of Justice to be able to have the technical skilled capacity to prosecute elite financial fraud. And he goes into that in explicit detail on a number of cases. So that's the power dynamic at work. But there are cases where actually the government, when it's working the way it should, can force guilty pleas, even in homicide cases. And this last case that we're going to look at is a case of BP in the Gulf of Mexico. And that's on April 20, 2010, while stationed at the Macondo well site in the Gulf of Mexico, BP's Deepwater Horizon rig experienced an uncontrolled blowout and related explosions. BP admitted that the two highest ranking BP supervisors on board the Deepwater Horizon, those were known as well site leaders, negligently caused the deaths of 11 men and the resulting spill of 210 million gallons of crude oil into the Gulf of Mexico. That was the worst oil spill in American history. And federal officials alleged in a criminal complaint against the company that on the evening of April 20, the two supervisors observed clear indication that the well was not secure and that oil and gas were flowing into the well. Despite this, those two guys chose not to take obvious and appropriate steps to prevent the blowout. And as a result, the well was lost, resulting in deaths of 11 workers and the spill of the crude oil. And then in November 2012, BP Exploration and Production pled guilty to felony manslaughter, environmental crimes, and obstruction of justice, and paid $4 billion in criminal fines and penalties. So that's a case where, you say it's really hard to bring these companies to admit their guilt, especially in homicide cases. That's the one outlier where it actually did happen. And these cases are probably just the tip of the iceberg. I mean, I was reading a case yesterday. There was a review in the New York Times about a coal ash spill years ago out of a TVA area in Tennessee. And one of the reporters down there pushed for a grand jury, and there was a grand jury convened, but the state grand jury decided it was more like of a federal action, and they deferred to the feds. But these cases happen a lot, and then you watch the corporations power play against the prosecutors. So my guess is that most major corporate tort wrongs, especially those result in deaths, eventually are criminally investigated or prosecuted. But the tug of war that results with strong corporate powers on one side and weak, poorly funded public prosecutors on the other give the corporate powers the advantage. So while you and I will certainly go to jail for reckless driving that kills others, the executives of corporations that engage in reckless behavior most likely will not.
Hey, thank you so much. Thank you for all the really important work you do, Russell. I think you've answered this in part, but what are the incentives that the Justice Department entertains that allows corporate interests over recommendations from their own prosecutors? Like, what are the points of leverage specifically that corporations can use that are not available to the public? Thank you.
Well, I've asked this of corporate defense attorneys, and they generally downplay this factor, but I think it's really important. And that is, if you're a young prosecutor working in DC or New York, those are the two power centers on corporate crime. You're getting paid as a young prosecutor, probably over $100,000. But your colleagues, people you went to law school with, are being paid far more, and they're on working for corporate criminal defense firms, and they're on partner track to make, millions of dollars. So corporate criminal defense firms love to hire young prosecutors because they have experience in bringing these cases and they know the ins and outs, and they have contacts at the Justice Department. So the revolving door is key here because it sort of corrupts the system. There's a lot of influence being peddled that way. And my sense is that's fundamental. The other is the corporate law firms know that the institution of the prosecutor's office are very weak. They're poorly funded, and they want to keep it that way. Their lobbyists work on Capitol Hill to ensure that there's no increase in budget for the Justice Department, for the corporate crime police, effectively, for the prosecutors who prosecute these cases. So if there were an increase in resources, and if there was a way to somehow slow the revolving door, that would be two ways to sort of push the system towards more equitable outcome.
My question is, when those two airplanes went down and killed all those people, I thought Boeing should not be allowed to be in business anymore. And yet after that, the doors fell out, this happened and that happened. And Boeing still has major military contracts. And every time I see Boeing getting a reward, I just cringe. And I felt the same way about the blowout in the Gulf. Why was BP allowed to stay in business after they made, and the crude was going into the Gulf for what seemed like days, and BP was still allowed to stay in business, and they still pollute Cancer Alley, and we should be able to get rid of the companies. It's no lesson when the companies go bankrupt and they just go on and still collect huge amounts of money, especially Boeing from the military industrial thing, and BP just from all kinds of exemptions for their waste. It's really kind of awful for those of us who are paying the least bit of attention to what's going on.
Well, it sounds like you're in favor of the corporate death penalty. And coincidentally, in another publication that I edit, the Capital Citizen, we're running an article in the next issue titled "Bring Back the Corporate Death Penalty." And the author, Mike Ferner, has this to say. I'm just reading the quote from the upcoming article. "We need a cultural and spiritual change that will produce courts and legislators that treat corporations the way Judge Finch did the North River Sugar Corp when he said its life was less than the humblest citizen before he revoked its charter and dissolved its assets." I don't know when that was, more than 100 years ago when that happened. But there is a history of revoking charters of corporations that engage in egregious behavior. So there is writing and a history of that we're starting to follow up on.
When we hear about these large corporate settlements, the $4 billion BP settlement, where does that money go? I always hear about these fines and then they're settled. Does it just go into the general treasury, or does it go to address the harms that were caused? So when a $4 billion settlement lands, where does that money go? Thank you.
These settlements are increasingly just contract agreements between the government and the corporation. So it's whatever they decide. Like, for example, in the Boeing criminal settlement, Boeing, to try and diffuse the anger and undermine the tort cases, agreed to pay each of the families $1.5 million. That was part of the settlement. The other part of the settlement, it was a huge settlement, I forget the number, but the other part of the settlement was actually just to pay off the airlines who were going to sue them anyway for damages. So most of the time, the corporate crime settlements go into the US Treasury, but often there are these kind of PR settlements where money gets distributed to various places.
Thank you. Thank you for this revealing program. Can you discuss a bit the corporations that are failing to follow environmental laws and protections? And I'm thinking about areas where we've got people who often live in close proximity, or toxic chemicals in the air going downstream, which are hidden from the public, or smoke from a fire, releasing chemicals into the atmosphere, with media saying there are no chemicals in it, and we know there are very dangerous chemicals there. What do we do? What's happening with that? Are we getting to a point where we're following more closely these issues that affect people's lives and their ability, even for farmers and things, to do, to be able to grow crops in an area like this? And we've seen many.
Yeah. This is a big scandal. Corporate criminal environmental enforcement has declined precipitously over the years, including under Democratic administrations, including under the Biden administration. The Biden administration made a great hire when they hired David Ullman, former professor of law at the University of Michigan School of Law, to be its criminal enforcement chief. But Ullman came in late. His nomination was not approved by the Congress until months after he was nominated. So yeah, it's a scandal that the Justice Department has failed to enforce the law in this area, and I don't think it's going to be turned around anytime soon.
Excellent. Thank you, Russell. And I did just want to mention that the Tort Museum features a case against the Ku Klux Klan that led to criminal prosecution of Klan members. In 1984, the Southern Poverty Law Center filed a lawsuit for violation of the Civil Rights Act and for the commission of the torts of assault and battery on behalf of Beulah May Donald, Michael's mother. She sought $10 million in damages from the United Klans of America, and to win, the plaintiff had to prove a civil conspiracy between the two killers, the local chapter of the UKA and the UKA's national organization. So thanks so much, Russell, for sharing all of these revealing incidents. And I would like to now introduce our next speaker. And although he needs no introduction, Ralph Nader has founded dozens of organizations, including Public Citizen, the Center for Auto Safety, the Center for Study of Responsive Law, and the American Museum of Tort Law. He has played a pivotal role in advancing auto safety, consumer, and environmental protection laws, and his two latest books have just come out. Let's Start the Revolution, which is, let me just read the sub part of that, which is Tools for Displacing the Corporate State and Building a Country that Works for the People, and Out of Darkness. Welcome, Ralph.
Thank you very much, Melissa, and everyone else who made this possible. The viewers should know this is an annual National Tort Law Education Day, and so you might want to spread the word about this hundreds of years old system of private law that is to be used by citizens, not by the government. The citizens use tort law, or the law of wrongful injury. They see that they've been wrongfully harmed. They go to a tort lawyer, contingent fee, file a case, trial by jury, guaranteed by the Constitution. That's the theory. But what you've heard today is, like any aspect of the rule of law, is subject to predatory action by corporate power, political power, economic power, government power. There's a massive attack that has been accelerating decade after decade against systems of law that protect people, whether they're workers, consumers, patients in the medical area, communities, you name it. We can see it over the years. As the society gets more complex, more technological perils, more environmental perils, more fine print contracts, more government intertwining with corporations, what Franklin Delano Roosevelt referred to as the corporate state, when private power controls government, more money into political campaigns, more control over the mass media, fewer media outlets for the voice of dissenters like Phil Donahue's show demonstrated over the years, we're in a real crisis. And when we have a crisis like this, it's logical to say, where are the law schools? The law schools, with few luminous exceptions, and you heard one today, Professor Birch, are not exerting any clarion calls. Their courses are like trade schools. They teach the students how to service corporate law firms, commercial uses of the law, some valuable, how to convey deeds, houses, draft certain contracts between buyers and sellers. But by and large, they don't pay attention to lawlessness. I've suggested they should have a whole curriculum called lawlessness. Because when you look at environmental laws, consumer laws, labor laws, you can see massive lawlessness with impunity by corporations. A major function of these corporate law firms is to get the companies to escape law enforcement, to get law enforcement budgets, as Russell pointed out, to be very tiny. It's like having 20 cops in Manhattan during a street crime wave. And you see this across the board. So the purpose of Tort Law Education Day is to point out a much larger phenomena, which is we have a lot more rights than we're using under the law. People often say we want reform, we need new rights, we need new controls over latent pollutants, for example, tighter controls over corporate subsidies, for example. And that's all true. But just look at the rights we have that are minimally used by a tiny percent of the citizenry. One is running for office. There are all kinds of thousands of local offices that don't even have an opponent to the incumbent. It's not just town councils, it's the zoning commission, the health department, and many others. Thousands and thousands of them where there isn't anybody running for office until somebody in government just begs somebody to run. We have half of the people who don't use the voting franchise, give or take, in terms of what year the vote is occurring. They stay home. We have a lot of towns in half of the states who have referendums. People can put a referendum on the ballot with a certain number of petitions, and they can be their own legislature. If the legislature is in thrall to, say, the insurance lobby or the bank lobby or whatever, those are not being used. Small claims courts, they were designed so you didn't need a lawyer. You just went there, paid a small fee, made your case, and got a judgment. Small claims courts now are mostly used by creditors, like landlords, against tenants. They're not used by consumers. The same with free speech. How many people's lives would be changed if we abolished free speech? A lot of people's lives wouldn't be changed because they don't exert it. They don't exert political speech or civic speech. They just mind their own business. People can start cooperatives, consumer cooperatives, food cooperatives, emphasizing nutrition, educating youngsters about good food, how it's grown, expanding local gardens. Nobody stopped people from that. They can use the Freedom of Information Act, which is in every state and federal. That's who uses that law. The government doesn't use Freedom of Information Act. It's people who use it to get files, secret files or reports on meat and poultry inspections, nursing home inspections, etc. Very few people use that. You have these big institutional shareholders that own huge amounts of stock of these giant corporations in the drug, oil, gas, banking, insurance industry. They're called Fidelity, Vanguard. They don't use the power that they have as well. You have this phenomena of simply not using the rights that you have. And that is one reflection of our vacuous educational system, where civics skills, civic courses are almost a thing of the past. They've been replaced by the computer. And so part of the non-utilization or underutilization is tort law, the law of wrongful injury. Now, my dad once said when we were young, if you don't use your rights, you're going to lose your right. And there's a lot of truth in that. If you don't use existing rights based on laws or regulations, what happens? Well, they become deteriorating. They become prey for weakening by corporate interests because there's nobody using them. And by definition, if you don't use them, you're not likely to defend them. So small claims court is an example of that. If you don't use them, talk them up by the consumer side, they become less and less usable. The fees increase for just ordinary people using small claims court. It gets very, very difficult. And that is what's happening to many of our legal institutions. And now we'll focus on the civil justice system, which is, of course, the embodiment of the law of torts or the law of wrongful injury. So if you look at the available studies, Rand Corporation had one, there should be better. I think it's fair to say that about 95% of all actionable wrongful injuries, medical malpractice, for example, toxic exposure, for example, product defects, never see a lawyer. That's how heavy the underutilization is. And there are a lot of reasons why they don't see a lawyer. One is they don't even know about it. There are people coming into the Tort Museum since it opened in 2015. By the way, the only tort law museum in the entire world. What's that say about the legal profession? There are 32 timber and lumber museums in the U.S. Anyway, they come in and they say, what is torts? One time a teacher came in with students. She said, we're curious. What is tort law? Well, you know, you have the computer, you have the internet. You could have found out something about it. But that's the level of the lack of knowledge. And that's why Melissa Bird and others at the museum are busy trying to get tours from high school students, middle students, community college students to the museum, about which we'll mention some things that can be done. Now, what's happened if you underutilize the civil justice system is its great pillar, trial by jury, begins to atrophy. And as Joanne Doroshow, the Center for Justice and Democracy in New York City, has documented, including the National Center for State Courts in Virginia, the civil jury is heading for extinction. Sometimes when you take all the tort cases filed, like you have 97% settle. They never even go to a jury. They don't even go to deposition sometimes. So what's happening is this great institution of trial by jury, the pride of America, for civil cases is atrophying. It's disappearing. And a corollary of that is that a lot of people, when they get a jury summons, think it's a pain in the neck. Instead of one of the greatest honors that can be accorded a citizen in a plausible democracy, they want to get out of it. In the District of Columbia, a lot of people just throw the summons in the trash. And of course, the district government doesn't have the resources to cite them. And so the jury pool shrinks and shrinks. So people in the district, some of them get a summons every other year, when it would be every 10 years, say. So this is what happens. We begin losing what we don't use. And in one area after another, it starts to infect the culture. You have people who are clearly malpracticed. The doctor admits it. And someone, for example, has a colon perforated during a colonoscopy. And the question is, well, are you going to file a lawsuit? And the insurance company is likely to settle because it's a slam dunk tort and it's admitted by the doctor. No, I don't want to do that. I don't want to get involved. I don't want to sue. So it gets embedded in the culture. As a result, the aggregate impact is the following. The fewer actionable lawsuits that are filed on all the different hazards and harms that occur, the less information gets to the public. The fewer lawsuits that are filed, the less deterrence there is against other wrongdoers doing the same thing, who look at the lawsuits and say, we better clean up our act. It may come to us. The fewer lawsuits that are filed, the more Medicare has to pay for medical expenses, the more Social Security disability payments. Because if you have tort recovery, you're not burdening these social safety nets supported by taxpayers. And the fewer lawsuits that are filed, the less the regulatory agencies hear about hazards that they should be regulating with mandatory standards or holding public hearings. The fewer lawsuits that are filed, the less the state, local, and national lawmakers in Congress and state legislatures hear about things that they should hold public hearings on. The fewer lawsuits that are filed, the less regulatory agencies get information. We got the tire industry regulated back in the 1960s because there were several lawsuits against tire makers in Akron that showed very, very inadequate inspection of tire defects. And the material we gave to Senator Gaylord Nelson of Wisconsin, he went on the Senate floor and demanded hearings, and we got legislation. The same could occur to activate parts of the Environmental Protection Agency, the Federal Railroad Administration, the Food and Drug Administration, the Auto Safety Agency, who hear far too much by corporate lobbyists who visit them every day in Washington and too often get their way. So it matters. Not just people don't get compensated for pain and suffering, for their medical costs, for their wage losses. It's horrible what's going on. And the workers' comp system, which was devised to replace the tort system early in the 20th century in America, to make recovery for workers certain and, they didn't say this, minimal. So they have to go through the risks of losing in court and the expenses. There'll just be a chart. So much for a leg, so much for an arm. It's called a meat chart in plaintiff legal circles. So you have 65,000 plaintiff lawyers, give or take, practicing in America. Can you imagine if every plaintiff lawyer just meets with various groups, high school assemblies, social service clubs, and speaks to 1,000 people in his community? You know what that totals? 65,000 lawyers over a period of 12 months, speaking to luncheons, speaking to the various existing groups, Kiwanis Club, things like that. Those 65,000 lawyers would reach 65 million people. Just something that simple. Taking a few minutes out of your practice, maybe at lunch, or being invited to one of these groups. Now, there used to be an educational effort called the People's Law School, and it was a marvelous effort, maybe about 25 years ago, led by some upstanding plaintiff lawyers in communities around the country. And they basically provided, for a minimal charge, about 6 or 8 seminars on different aspects of the law: tort law, contract law, housing law, civil rights law. And then they gave people a diploma. That's why they called it the People's Law School. Somehow, it sort of faded away. I could never understand why, because the materials that they pulled together were about 8 inches high. And amazing education for people who, regardless of their level of formal education, never really learn about the law. The law is not just for law students. That's caused us a lot of deprivation and deterioration of our democratic society. So what do you do about this? Well, one is you activate adult education courses. They're all over the country. Insert People's Law School type materials. The second is high school and middle school. There's no reason why they can't learn about tort and contract law. Contract law, by the way, the fine print contracts take away your tort rights. Some of you may have squinted on page 28 of whatever company you're asked to sign on a dotted line, or if you're lucky, click on and see. They basically say that you've agreed not to sue them. You've agreed to go to compulsory arbitration. You've agreed not to have a trial by jury. You've agreed to give up your constitutional rights. And that's rampant, because these contracts are written by one side, the vendors, the insurance companies, the banks, the landlords. You've seen them all. They're very complex. They're unreadable. Sometimes the print is so small you can hardly see. The Airbnb contract that I saw a few years ago was 68 pages for a homeowner to sign. What do you think's in that 68 pages? You think it's homeowners' rights? That's how they tilt the balance and control the economy. And now they're overreaching to cannibalize tort rights. So can these youngsters learn the rudiments of tort and contract law? Of course they can. My sister, Claire Nader, has written a book called You Are Your Own Best Teacher, directly focusing on 9, 10, 11, 12-year-olds, even though it's very useful for teenagers as well. And there's about 50 topics to liberate these youngsters' mind, tap into their basic curiosity, intellect, idealism, and free them from the internet gulag and 5 to 7 hours a day on that incarcerating and corrosive iPhone. And a couple of the 50 are teaching torts and contracts. And people have said, what? How can you teach torts and contracts? These kids, I mean, they're many years removed from law school. Well, take a look at the book. You are your own best teacher. It had 13 marvelous endorsements when there was a full-page ad on the book in the New York Times Sunday Book Review. These people know what they're talking about when it comes to educating children and, shall we say, supplementing the inadequacies of their formal education in the classroom and actually improving their classroom performance when the children learn what's in this book. So why don't we do that? Whenever we talk reforms, we should talk about things that no one can stop us from doing. There are reforms, you know, you try to reform the corporate tax loophole system, you're going to have a lot of lobbyists and indentured lawmakers fight you. But these kinds of things, nobody can stop you from doing all this. You can have afternoon classes, for example, for youngsters. There are all kinds of ways to get the information there. So you have adult education, you have part of the high school. Now, the Tort Museum has a high school tort curriculum, tort law curriculum. It's on our website, tortmuseum.org. It's really quite simple. You can persuade a social studies teacher. They're very responsive by and large. They have been disrespected by the STEM educational lobby. Like everything these kids should know should be about computers and code and so forth, so they can be cogs in giant corporate wheels when they grow up. So you get social studies teachers who will be responsive to that. Now, just a few quick comments on the speakers. The first speaker, David Tannenbaum, his presentation was really quite intricate. I hope you spotted some of the areas that David Tannenbaum didn't have answers to, like autonomous weapons run by artificial intelligence. The Pentagon and other foreign militaries are working on it. But the big question of artificial intelligence is it too complex, too mutating, too immediately masticizing, too secretive to be confined within a framework of law and ethics? In other words, is it so run away from us now that it is beyond the effective limits of legal action? Whether it's lawsuits, whether it's regulation, you name it. It's out of control. And it doesn't respect national boundaries. It floats all over the world. We don't know where it is. Who owns it? Who owns part of it? Who is now going to be expelled by the artificial intelligence robot itself that doesn't like who controls it and turns on its owners, Frankenstein style? This isn't science fiction, as you know. It's here now and moving under cloaks of copyright, patents, secrecy, just the opposite of being drawn in to the web of a vigorous, up-to-date, engaged democratic society. So that's one. Comment on Professor Birch was the Boeing case is a perfect example of how the right of trial by jury, individual case by individual case, such as the next of kin to the relatives lost in the Ethiopian crash by the homicidally designed Boeing 737 MAX. And these families were told by their plaintiff lawyers that they're going to be represented vigorously. Some of them said, we can't wait to get these corporate executives in Boeing on the witness stand and tear them apart. And before you know it, these cases were melded into a mass tort circle, which means that increasingly it's one shoe fits all. Increasingly, instead of 150 lawyers participating, they all defer to maybe a half a dozen lawyers who take aviation cases and are very, very congenially interactive with the defense corporate law firms that they work out the deals with. And so it's almost unheard of for passenger crash fatalities to end up in a trial by jury. If you look at the major airline crashes over the last 30 years, almost all of them are settled. There's no such thing as trying these cases. And the Boeing case is heading down that route. The judge, who, like most judges, doesn't like to work hard and try one case after another. It's hard work, day after day. Tedious. So it's much easier to say, you should try to settle. So they set up a mediation system. which becomes very coercive because it's not just the defense firms telling the plaintiff lawyers, we can delay you for 5, 10, 20 years. We're experts in delay. When are you going to get your fee? When is your client going to get paid? And the lawyers on the plaintiff side say to themselves, they probably can do that. We better try to go to mediation. So all the pressures to go to mediation while the discovery process is held up. To this day, there hasn't been a single trial over 5 years after the crash on the Boeing case, and there have been no depositions of the major suspect, the CEO at the time, the head of the board of directors, and other Boeing executives who turned a once proud engineering company into a financial speculative stock value company and subordinated their engineers to these commercial imperatives, restricted their judgment, understaffed, and so on and so forth. So let's talk more about the judge's performance when we talk about mass torts and multi-district litigation, not just the lawyers, because from what I am observing, these judges are aborting the civil justice system in terms of its being able to command an open trial by jury, full disclosure under discovery, the press there, anybody who wants to walk in the courtroom can do so, same for the appellate argument, and producing verdicts that deter unsafe practices in the industry, that disclose information millions of other unsuspecting consumers would want to know about, like food safety cases, for example, and, of course, compensate the victims or the next of kin. So when you have the narrative that Russell Mokhiber gave us, here's the bottom line. If people in cities are having their youngsters beat up by police brutality and they expect the prosecutors to bring these off-the-limits police to justice, and they don't do that, the prosecutors go to work often in the same building where the police are, and they're very reluctant to bring cases against the police, and we have to recognize that there are a lot of juries that don't want to convict police charged with police brutality. What's left for the families, the next of kin? The tort system. So there's a 12-year-old who was subjected to a brutal shooting in Ohio, and he was killed, and the prosecutor would not prosecute. The family sued the city and got a $12 million settlement under tort law. So that's one example that's there. We should always keep in mind here that tort cases are human interest on steroids. They're fascinating, they're engrossing to people. We're not talking about some regulation under the securities laws that no one can understand. So we are advancing something people inherently are interested in. That's why when they go to the Tort Museum, even if they are infiltrated by the insurance company propaganda about frivolous suits, ambulance chasing lawyers, they go through it and they actually find that their minds have changed. You know how hard it is to change people's minds? Look at the current election. They actually have their minds changed because this one inveterate museum visitor told us on his way out, he said, I've been to over 100 museums. This is the first one that respects my intelligence because it asks little questions like law professors would ask. Well, what if the factual situation in this case changed? How would you have come out? So it even deals with the short attention span of children who, when they go to some tour destination, they're very agitated and they're grabbing their phone and so on. It really grabs the attention because of the artistic design, the graphics, and the human interest. People resonate because it reflects their own life experience. Who hasn't been experiencing auto crashes, hospital mishaps, workplace safety situations? So that's the plea for far greater civic engagement in reactivating civil justice law, utilizing it more, advancing it to keep up with new technology, and building it right into our educational system from our elementary schools, high schools, colleges, right into the adult education milieu that I think would be quite receptive. But it has to start with trial lawyers, with paralegals, with what's called ordinary citizens, which local civic groups. That's where it starts because that's where most of the torts are prevailing. Thank you.
Thank you, Ralph. I was all fired up when you first came on, because I heard Russell talk about revolving doors and corporate power and occupied Congress. I was so frustrated. But based on what you're saying, we got to sue these people. We got to go to the first step. And I don't know what the first step is in the case of revolving doors or too much corporate power or Congress that's, getting bribes. But I guess it's tort law is the answer. Wondering if
Well,
you
that's
have
one answer. There are a lot of handles that citizens can use to advance justice and deconcentrate power, shift power from the few to the many, and make the few who abuse their power accountable. Remember, we outnumber them. There are 1,500 or so corporations who pretty much control Congress. They don't have any votes, at least not yet. We outnumber them. I've often said, take some of the major changes we'd like, long overdue, living wage, full Medicare for all, single payer, cracking down on corporate crooks, changing the tax system. It takes less than 1%. Vigorous civic engagement, that's 2.5 million people in 425 congressional districts. That's 1%, 2.5 million adults. And, that's less than engage vigorously in bridge games and bridge contests. If you've ever seen how intricately organized the bridge fans are around the country, you can only relate it with awestruck reactions. It's amazing, the intricacy, the time they spend. Well, how about a Congress Watch club in every district? And so you say, how could that be? 1%? Impossible. Corporations too powerful, got their hooks into all these senators, representatives. Remember, there's one thing that these senators, representatives want more than campaign money. It's your vote. If your vote is passive, if it's not sharp enough, it's not conditioned, not demanding, then the money will nullify the vote. And, you'll trudge to the precinct and cast your vote between two major parties comprising a duopoly, unless you vote for a third party. So here's how 1% or less can prevail. In fact, we regulated the auto industry in the 1960s, and I don't think we had 1,000 active people around the country. Why? Well, people knew about car crashes. You didn't have to explain. It wasn't fine print. They probably experienced crashes or had relatives or friends. They thought it was a good idea to recall defective cars. They thought it was a good idea to have safety standards for crash protection and better brakes and handling. So, it was common parlance. It wasn't obscure. But here's what you need for 1% or less. You need 1% who volunteer what's equivalent to a hobby time allocation. Say 500 hours a year, which is what a lot of people put on their hobbies. And they open up a full-time office. They put some money together. And they have a couple of staff in each congressional district. And they know what they're talking about. They're accurate. No disinformation, and they keep up to date. That's the one criteria. The second criteria is they reflect public opinion, either existing or easily amassed with education. And you can make a list your arm long of all the things that there's left-right voter support for. Universal health care, living wage, as I mentioned, cracking down on corporate crooks. 85% of people want higher taxes on the super wealthy and the corporations who are undertaxed, if they're taxed at all, given the loopholes. A lot of things. People would like benefits and Social Security frozen for over 50 years, raised, a lot of things. The third criteria is that you focus all that civic energy, knowledge, and demand on the forum that you expect to make the decision. You don't just have a huge march on Saturday afternoon and the energy goes up into the ether. No, you turn it into focus on your lawmakers, the Congress, state legislature, the city council. So take your choice. Pick your hobby. Pick your civic hobby. There's plenty for everybody. There are also all kinds of civic action manuals, how to hold a press conference, how to provide a voting record, on questions that the press never asks the candidates about. They don't ask them about, okay, Trump, okay, Harris, what's your position on corporate crime? We got a corporate crime wave. What's your position on corporate subsidies, handouts, giveaways, government guaranteed capitalism? That's hundreds of billions a year. Come on, what's your position? You have never mentioned it on your campaign trail and in your speeches. So you ask a very important question, and it was a long answer, but thank you.
Our next question comes from Francis. We're faced with deadly, unsafe food products being recalled. Where is the accountability?
Well, they're usually followed by a lawsuit. There are food safety lawyers. There's a fellow up in Seattle, it's called Mahler, who specializes in watching for the recalls, like the E. coli with the onions in the McDonald's case. It's in the news these days. They get wind of it because people get sick. They go to doctors. The press reports it. Some of them don't survive, and they will file a tort lawsuit against the company. So it, almost without any doubt that McDonald's is going to be sued on this latest lethal food contamination. Or its supplier. McDonald's could turn around and sue its onion supplier, for example, to try to reimburse McDonald's, but they can't escape accountability because they were in the trail of sale here, and it was their product. So there are a lot of these. They do deter. Some of these companies have been driven out of business. Smaller companies, food companies, asbestos companies, they do deter, and they do follow recalls. I'm sure that there's a website that keeps you all up to date on all these recalls and the lawsuits on the internet.
With the move towards contractual waivers of class inclusion as well as arbitration clauses, how do we keep doctrine evolving and continue to utilize the tort system to regulate corporate powers?
Well, some judges are overturning some of these arbitration clauses as unconscionable. That's a long time use. When you have contracts that are so cruel and one-sided, they can be invalidated, even though they're private contracts and someone has signed on the dotted line without ever being able to understand what all the terms are. I just saw something from the Bank of America in the fine print at the bottom of a monthly statement. Listen to this. It says, terms and conditions can be changed without notice. That's how far the contract peonage, the contract servitude, the destruction of our historic pillar of freedom of contract that conservatives always like to hold up as part of our liberties has gone. That what Bank of America is basically saying, they can change the contract with you, the depositor, that's giving them the money from which they're making more money, without even notifying you. Well, I don't think that would hold up. I think the judge would say, that's just absurd. That didn't really get the consent, even though they might be able to point out the bank that you signed something when you opened the deposit and you waived all your rights against what they call unilateral modification of the agreement by, in this instance, the bank. So we want to press forward on that and try to get more invalidated. A more basic thing is to crowdsource it. You put up some of these fine print contracts that you have to sign, and we all have to sign them, and you ask the public out there to rewrite them. Write it in a way that's fair, readable, intelligible, accountable between seller and buyer. And that could become very effective way to it. You get a lot of input on that, and it certainly doesn't cost much to do that. A third way is to get model contracts. Like years ago, there was a plain language movement, and Kemper Insurance actually rewrote their pages of fine print into far fewer pages with larger print. They simplified. And we need a simplification movement. Complexity helps the few control the many. We all know that. The more complex the forms are, the tax forms, the more complex the contracts you sign, the landlord leases, on and on, the more you basically are told, give up, sign on the dotted line. The more they expect you to say, take me, I'm yours. And they're very willing to do that. And they control you with the credit score. You ever see the agreement where you agreed to abide by a credit score that can affect the interest payments or whether you can even get a loan? Who figures out this credit score? Who gives you the number? Can you argue with them? Can you get them on the phone? Press 1, press 2, voicemail, never get back. So these require new citizen groups, new consumer groups. Just like in the 1970s, started out with new environmental groups, and they made a big difference. We need new groups being formed. Companies have startups all the time. We need startup traditions in the civic arena. Look, everything starts with citizens. You name a major thing that we like about our country in terms of the blessings that we inherited from our forebears. You think they started with an elected official? You think the women's suffrage movement, the abolition movement, the labor, farmer, progressive movement, they all started with a few farmers, a few workers, a few patients, a few women, a few escaped slaves. So that's where it all starts. And so in answer to that constant question, what do we do? What can we do about it? How can we change it? Look in the mirror. It all starts with a few people. And there are tons of articles written on how a few people persisted and changed the scene, changed the injustice. We all know one person can make a difference. The key, given the volume of challenges against democracy, the key is, can many people get together to make a bigger difference? That's the key. So when you hear people say, I don't want to go to this town meeting, I don't want to go to this civic gathering, I don't want to go to this agency hearing, you're basically saying you don't want justice. You're basically saying, are you a masochist? I mean, do you really think it can be done without you? So you have to get a little tough love with our neighbors and friends. It's not easy, but it's happening around the country. There are things, big fight against the pipeline and in the Dakotas, people getting together, stopping major corrosive developments. They're not publicized as much as sports and Taylor Swift and so on, but they're there and you can find them on the internet.
Great. Thank you, Ralph. I just wanted to mention, Ralph mentioned a recall website. That would be www.recalls.gov. And I would like to first thank our panel, David Tannenbaum, Elizabeth Birch, Russell McIver, and Ralph Nader. We appreciate being able to offer this experience to the public who are thirsty for this type of insight into our justice system. And I want to thank all of our guests for tuning into this thought-provoking dialogue. It's really crucial to understand that the presence of a robust legal framework is what strengthens our democracy. I'd like to give a shout out to our sponsors once again for supporting the mission of the American Museum of Tort Law, Klein and Spector, Bellick and Fox, and Laboratories for Democracy presenting their Youth Civic Challenge, which is a national civics program. Again, please visit our website, www.tortmuseum.org. And if you happen to be in the northwest corner of Connecticut, checking out the fall foliage, please stop by the American Museum of Tort Law for a tour. We are open Tuesday through Sundays. And thank you for joining us.
Thank you indeed.